give you a brief introduction about him. Sir has completed his law graduation from Government Law College, Mumbai. He was enrolled as an advocate in High Court of Kerala in 1979. During the years from 1983 to 1985, he was a secretary of the Rule Committee considered by the High Court of Kerala. During the years 1983 to 1980, he was directly recruited as a district and session judge in the year 1987. From 1988 to 2000, he has held various posts in the district judiciary. From 2000 to 2004, he was the law secretary to the government of Kerala. He was appointed as permanent judge in the High Court of Kerala in 2004 and served as a judge from 2004 to 2012. While in High Court, he has pronounced several landmark verdicts. And after retirement from the High Court of Kerala, he was serving as a chairman for advisory board under Kerala Anti-Social Activities Prevention Act for over 3 years. Sir is frequently invited by Kerala Judicial Academy for taking classes for judicial officers, police officers, public prosecutors. And his articles on various branches of law are held in high esteem by the bench and bar of this country. We welcome you to the webinar, sir. And before we begin, there shall be a question and answer session after the webinar. Yes. Over to you, sir.
Thank you. Thank you, Sunita. Good evening, friends. My usual caveat, I am not an expert on criminal law. I am only a facilitator, and who is rather a facilitator who is willing to share his experience and knowledge with you in the expectation of learning a lot from you as well. Therefore, wherever I go wrong, you are free to correct me. With that, we begin today's lecture. In fact, this is actually the third part 3 of my lecture series. That is part of investigation starting from FIR to final report. This is part of that series. This is the third part 3. Now, Sunita, please read question 1.
Yes, sir. Question number 1. What is an inquest?
An inquest is an inquiry into the manner of death of a person who has died under suspicious circumstances. In England, such inquiry is conducted by a coroner or a medical examiner. Coroner is a public official whose duty is to investigate the cause and circumstance of the death that occurs suddenly, suspiciously, or violently. Among other things, the duties of the coroner consisted of holding an inquest upon the dead bodies. A coroner's court in English law is a common law court that holds an inquisition if a person died a violent or unnatural death. This is what is called inquest. So holding an inquest. Here in India, that function is taken over by the police itself by virtue of section 174 of the Code of Criminal Procedure, CRPC for short. Yes. Question number 2.
Question number 2. What is an autopsy?
An autopsy is the medical examination of a corpse to determine the cause of death, especially in criminal investigation. It is also called postmortem or necropsy. Postmortem or necropsy. The doctor, the medical, usually in our state, is a forensic surgeon who is also a police surgeon. He will come and prove the autopsy. That is a medical examination of the corpse, the dead body. And we also call it postmortem or even necropsy. Question number 3, Sunita.
Question number 3.
Yes.
Which is the enabling power of an SHO to hold an inquest over a dead body?
The enabling provision is, as I mentioned earlier, section 174 of the Code of Criminal Procedure. Section 174 gives the power to the police as well as to the executive magistrate to hold an inquest. The usage is to hold an inquest. You don't say conduct an inquest. You conduct an investigation or conduct an inquiry, but holding of an inquest is usually done by the station house, the officer in charge of a police station. Yes, now please, you've shown the chart. I've prepared a chart showing the police inquiry on the left side and magisterial inquiry on the right side, both in the case of a dead person, both falling under, in fact, police inquiry is falling under section 174 of the CRPC and magisterial inquiry under section 176 of the CRPC. The 174 by police I will see the column 1. When the SHO or some other specially empowered police officer receives information that there are 6 situations. A person has committed suicide. A person has been killed by another, or a person has been killed by machinery or by an animal. A person has been killed by an animal, or a person has been killed by machinery, or a person has been killed by an accident, or has died under circumstances raising a reasonable suspicion that some person has committed an offense. In all these 6 situations, the police officer will be justified in registering an FIR under section 174, not under section 154, because there is no cognizable offense revealed so far. It is yet to be seen. Therefore, an FIR will be registered under section 174. FIR means only first information report. It does not necessarily mean an FIR registered under section 154, because FIR is the abbreviation for first information report. So, first information report can be regarding the detection of a dead body, regarding under suspicious circumstances, or detection of a person, the dead body of a person who has had an unnatural death, suspicious death, etc., or violent death. So, first information report is the information given to an officer in charge of a police station, SHO, regarding a dead person. That's all. Therefore, these are the 6 situations whereunder a police officer, SHO, will be justified in proceeding to register an FIR under section 174 and conducting a sort of inquiry, which is actually investigation. Now, I'll read on. The SHO or other police officer shall immediately give intimation thereof to the nearest executive magistrate empowered under section 174(4) CRPC to hold inquest. See, under section 174(4), certain executive magistrate like district magistrate, subdivisional magistrate, or any other executive magistrate specially empowered by the state government or by the district magistrate himself. These are the empowered executive magistrates who are entitled to conduct inquest over a dead body. Therefore, once a police officer receives information regarding a dead person under any of these 6 circumstances, that is, a person has committed suicide, a person has been killed by another, or a person has been killed by an animal, a person has been killed by machinery, or has died or has been killed by an accident, or died under suspicious circumstances, evoking reasonable suspicion of the SHO or the person giving the information that some person has committed an offense. These are the 6 situations whereunder an SHO will be justified in giving immediate intimation to the executive magistrate. That is why when he registers an FIR under section 174 or under the caption unnatural death and forward the report to the executive magistrate, not to the judicial magistrate. That is the distinction between unnatural death and a cognizable offense being committed. Supposing a person has been murdered, supposing there's a clear case of murder reported, first information report is regarding a clear case of murder, he need not proceed under section 174. He can straightaway register an FIR under section 154 CRPC. In fact, after the constitutional bench in Lalita Kumari's case, he has no option. He has to compulsorily register an FIR. And if he has reason to suspect the commission of a crime, of a cognizable offense, he can enter on investigation. That is the requirement of 154. But here is a case where a dead person is found, a dead body is found. It is too early to consider whether there is an offense committed or not. Therefore, in such a situation, all these 6 situations which I mentioned, which is there in section 174(1), the SHO will be justified in registering an FIR under section 174 CRPC and immediately intimating the matter to the executive magistrate. There is a misconception that it is the executive magistrate who has to hold the inquest. No, it is for the police officer himself to hold the inquest. Therefore, before that, he has to give the intimation. As in the case of 154, When a cognizable offence is reported to the officer in charge of a police station, he is bound to register a crime and then give a report to the judicial magistrate having jurisdiction. That report is sent under section 157. Likewise, when an FIR is registered under section 174 with regard to an unnatural or suspicious death, he has to send an intimation to the executive magistrate having jurisdiction and then proceed to conduct, to hold inquest over the dead body. He shall immediately give intimation under 174, then proceed to the place where the dead body is found. He has to proceed to the place where the dead body is found and shall there means where the dead body is found. There, in the presence of two or more respectable inhabitants of the neighborhood, he shall draw up a report of the apparent cause of death. Apparent cause of death. He is only investigating or inquiring into the apparent cause of death. Describing such wounds, fractures, bruises, and other marks of injury as may be found on the body, and stating in what manner or what weapon or instrument, if any, he is not bound to conduct an investigation into who inflicted the injury or what was the circumstance under which the injuries were inflicted, or what was the weapon with which the injuries were inflicted. No, he is not entitled to conduct an investigation into those aspects. If those facts are discernible at the time of holding the inquest, he can record that. Then the report shall be signed by the police officer and other persons who concur therein and shall be forthwith forwarded to the district magistrate or subdivisional magistrate. This is his first step. Then see, what the police usually do is to when an information is received, they register an FIR under section 174. In fact, in various states, different procedures are in vogue, but actually there is no scope for any departure from this uniform procedure, which itself is prescribed by section 174. Because only thing is, it only mentions about information. Information means first information. First information means FIR. Therefore, once FIR is received by the officer in charge of a police station, he is to record that and register an FIR under section 174 because he is not sure whether an offence has been committed or not. But there may be cases where clear case of cognizable offence has been committed. In such case, he can straight away register an FIR under section 154. But here he is registering only an FIR under section 174. Then the scope of the inquiry under section 174 is very limited. Its object is only to ascertain whether the person had died under suspicious circumstances. If the death is under suspicious circumstances or is an unnatural death, what the police officer have to find out is only the apparent cause of death. Courts have taken the view that he is not entitled to conduct an investigation into who committed the offence, with what weapon, all those things, unless they are discernible at the time of inquest itself. Details such as how the deceased was assaulted, who assaulted him, under what circumstances he was assaulted, etc., are foreign to the scope of an inquiry under section 174 CRPC. The citations are Podda Narayana versus State of Andhra Pradesh, 1975, 4 SEC 153, AIR 1975 Supreme Court 1252, AIR 1975 Supreme Court 1252. Again, AIR 1975 Supreme Court itself 1324, 1324. Then AIR again his scope is very limited. He is not entitled to conduct a detailed investigation because this is not the investigation into a cognizable offence. He is yet to register a cognizable offence. He has only registered an FIR under 174. How did this man die? What is the apparent cause of death? What could be the apparent cause of death? From the by examining the body of the deceased person, by examining the injuries, bruises, marks of violence, etc. And prima facie, he will have to conclude what could be the manner in which this person met with his death. That's all. Again, Radha Mohan Singh, alias Lal Saheb versus State of UP, AIR 2006, Supreme Court 951. Then I read on in the chart. When the case involves suicide by a woman within 7 years of her marriage, or the case relates to the death of a woman within 7 years of her marriage, in any circumstances raising a reasonable suspicion that some other person committed an offense in relation to such woman. In these two cases, in fact, there are 5 cases contemplated by section 174(3), but but then first 2 cases where the case involves suicide by a woman within 7 years of her marriage, or relates to death of a woman within 7 years of her marriage, and there is reasonable suspicion that somebody had committed an offense. In these 2 cases, police can conduct the inquiry, including autopsy, etc. But then there is a mandatory duty on the executive magistrate also to hold an inquest and conduct an inquiry into the apparent cause of death. When we discuss section 176, we will do that. Second column is the magisterial inquiry. First column is police inquiry. Then third instance is when the case relates to death of a woman within 7 years of her marriage and any relative of the woman has made a request in this behalf. Here there is no mandatory magisterial inquiry. Police inquiry can be there. Then there is any doubt regarding the cause of death of the man or woman. Then the police officer, for any other reason, considers it expedient to do so. The police officer, for any other reason, considers it expedient to do so. In that case also, he can proceed to conduct an inquiry, including holding an inquest over the dead body. Then he shall forward the body for examination to the nearest civil surgeon or other qualified medical man appointed by the state government. If the state of the weather and the distance so admits, without risk of putrefaction on the road, rendering such examination useless. So after that, he has to forward the dead body for examination by a qualified medical practitioner, which we call autopsy or postmortem examination or necropsy. Then sections 175(1) CRPC close the police officer proceeding under section 174 with the power to summon persons for the purpose of his investigation, and such persons so summoned shall be bound to attend and to answer truly all questions other than questions, the answers to which would have tendency to expose him to a criminal charge or to a penalty for forfeiture, except in case where the answer will expose him to a criminal charge. He is bound to answer truly to the police officer. The police officer can summon witnesses. Then 175(2) enjoins that if the facts do not disclose a cognizable offense to which section 170 applies, such person shall not be requested by the police officer to attend a magistrate's court. Person so summoned shall not be requested to attend a magistrate's court if the offense disclosed is only a non-cognizable offense. That is column 1. Now we come to the magisterial inquiry under section 176, column 2. When the case is of a nature covered by clauses 1 and 2 of section 174(3), we already seen that. 174(3), where the case involves suicide by a woman within 7 years of her marriage, or where the case relates to the death of a woman within 7 years of her marriage, in any circumstance raising a reasonable suspicion that some other person committed an offense in relation to such woman. In these 2 cases, apart from the police inquiry, Section 176(1) says the shall be the nearest executive magistrate. See, as you find in section 167, when a person is arrested and detained, he has to be produced before the nearest magistrate, who need not necessarily be the jurisdictional magistrate. Likewise, in those two cases regarding a married woman dying within 7 years of her marriage, those two cases, the nearest executive magistrate has to conduct an inquiry under section 176(1). Then, in other cases, any executive magistrate need not be nearest, because this calls for some expedition, because the person died is a married woman within 7 years of her marriage. So the law gives some importance, some expediency to such cases. Therefore, take her body to the nearest, or bring the nearest executive magistrate, so that you don't lose time. To avoid loss of time, the nearest executive magistrate can be brought for conducting holding an inquest over the dead body, etc. In all other cases of death, the executive magistrate, he need not be the nearest executive magistrate, can empower to hold inquiry, of course, under section 174(4). He can conduct the inquiry. Then there is a 1A introduced by way of an amendment to section 176, 1A, where any person dies or disappears, or rape is alleged to have been committed on any woman, while such person or woman is in the custody of the police or any other custody authorized by the magistrate or the court under the CRPC. In addition to the inquiry or investigation by the police, an inquiry shall be held by the judicial magistrate. This is not executive magistrate. This is a provision where judicial magistrate himself has to, or a metropolitan magistrate himself has to conduct an inquiry within whose local jurisdiction the offence was committed. This is a case where a person escapes from custody, police custody, or is missing, or a person dies in police custody, or a woman is raped while in police custody. These cases call for an inquiry not by an executive magistrate, but by a judicial magistrate. The magistrate holding such an inquiry shall record the evidence taken by him in connection therewith in any manner hereinafter prescribed, according to the circumstance of the case. Whenever such magistrate considers it expedient to make an examination of the dead body of any person who has been already interred in order to discover the cause of death, the magistrate may cause the body to be disinterred and examined. If he has been already cremated or buried, then the body can be disinterred and got examined by the magistrate. Where an inquiry is to be held under this section, the magistrate shall, whenever practicable, inform the relatives of the deceased whose names and addresses are known, and shall allow them to remain present during the inquiry, so that the magistrate can instill confidence in the relatives that he is conducting a genuine inquiry, a purposeful inquiry into the cause of death, apparent cause of death of the deceased person. The judicial magistrate or the metropolitan magistrate or executive magistrate or police officer holding an inquiry or investigation under subsection 1A of section 176 shall, within 24 hours of the death of the person, forward the body for examination to the nearest civil surgeon, unless appointed in this behalf by the state government, unless it is not possible to do so for examination to the nearest civil surgeon or other qualified medical person appointed by the state. If the nearest civil surgeon is not available, any qualified medical person appointed by the state, and he has to record the reasons for that. There's an explanation that the expression relative means parents, children, brother, sisters, and spouse. All these persons fall within the expression of relative, who can be present during the conduct of the inquiry. Now, this is the chart. This chart will give you the basic idea, a bird's eye view regarding the police inquiry and the magisterial inquiry. Police inquiry under section 174 on the left-hand column, and magisterial inquiry on the right-hand column. And magisterial inquiry ordinarily by an executive magistrate authorized to hold inquest, but where the death is in custody or disappearance, man missing is in custody, or rape of a woman has been in custody, a judicial magistrate has to conduct an inquiry. This is the sum and substance of sections 174 and 176. Now, why not we go to the rest of the questions? Sunita, you may read question number 4.
Okay, sir. Question number 4. Should not the SHO obtain the permission of the executive magistrate for holding inquest of the dead body of a person believed to have died in an unnatural death?
That's what I said. See, there is a popular misconception that the police can only give an intimation and it is for the executive magistrate to hold the inquest. No. The police have to give an intimation, as in the case of cognizable offence FIR 154. Under 157, he has to forward a report to the magistrate, the SHO. Likewise, when the SHO is proceeding to hold an inquest, he has to give immediate intimation to the executive magistrate. So he is giving an intimation. That is why he will register an FIR under section 174 CRPC or under the caption unnatural death, and then forward that report to the executive magistrate. That will be the intimation in practical purposes. For practical purposes, that will be the intimation given to the executive magistrate. Then he need not wait for the orders of the magistrate. He can straight away proceed for holding the inquest. And that should be done at the place where the dead body is to be found. Therefore, the obligation of the SHO is only to intimate the executive magistrate and who is empowered to hold inquest. You may refer to Madhu versus State of Karnataka, AIR 2014, Supreme Court 394. AIR 2014, Supreme Court 394. Question 5, Sunita.
Yes, sir. Question number 5. What is the purpose of holding an inquest?
I already told you, the main purpose of holding an inquest is to find out the apparent cause of death. The citations are Podda Narayana versus State of Andhra Pradesh, AR 1975, Supreme Court 1252, George versus State of Kerala, AR 1998, Supreme Court 1376, then Amar Singh versus Balvinder Singh, AR 2003, Supreme Court 1164, AR 2003, Supreme Court 1164, and Shambhu Das alias Bijoy Das versus State of Assam, AR 2010, Supreme Court 3300. All these decisions unanimously hold the view that the main purpose is to find out the apparent cause of death. On an examination of the dead body, what could be your first instinct? How did he die? He is not expected to conduct a detailed investigation to find out who the offender is, what was the manner of infliction of the offense, how did he die, was there any eyewitness, etc. No, he is not entitled to conduct a detailed investigation. It's a sort of a summary inquiry. Question 6.
Question number 6. Has not the SHO the discretion not to send the dead body for post-mortem examination in a case where he entertains no doubt regarding the cause of death?
Not after 23/12/1983. Until 23/12/1983, he had the discretion. But section 174, subsection 3 was amended with effect from 23/12/1983. So there is a decision by the Supreme Court prior to 23/12/1983, wherein it has been held that he has a discretion to send the body for post-mortem or not. That discretion has been taken away by this amendment. Therefore, I will give you the citation, but it is no more good law in view of the legislative intervention. AIR 1975, Supreme Court 1925, 3 judges. Kodali Puranchandra Rao versus Public Prosecutor, Andhra Pradesh. AIR 1975, Supreme Court 1923, 3 judges. but no more good law because of the legislative amendment intervention of the legislature by way of an amendment. Yes, question number 7.
Question number 7. Should not the inquest report contain the incident, the manner in which the incident took place, name of the accused, etc.?
We already said that. It need not contain all those details because the inquiry by the police or the executive magistrate is very limited. Apparent cause of death. On an examination of the injuries, etc., and other things which are attending the dead body, whether he died, whether there is a reasonable suspicion of any person committing an offense against him, or whether it was an natural death. Natural means in the sense premature death. All those things he can examine. So he need not conduct a detailed investigation regarding the cause of death, apparent cause of death. Citations are AR 1997, Supreme Court 2512, State of UP versus Abdul, 1997, Supreme Court 2512. He need not conduct all those. How many witnesses were there? Is there any eyewitness? What was the weapon used? All those inquiry and investigation is foreign to the inquiry under section 174. Again, AER 1998, Supreme Court 1285, Sheikh Ayub versus State of Maharashtra. AER 1998, Supreme Court 1285. George versus State of Kerala, we already seen, AR 1998, Supreme Court 1376. Then, non-mention of the names of eyewitnesses in the inquest report will not render their testimony in court unreliable. Just because their names are not mentioned in the inquest report, you cannot say that when that witness deposes before court, his testimony is unreliable. There may be various reasons why his names are not mentioned in the inquest report, because as the Supreme Court has articulated, it is not necessary to mention how many witnesses were there, etc., while preparing the inquest report. Therefore, just because the names of witnesses have not been mentioned in the inquest report, those witnesses, when examined before court cannot look upon them with suspicion. The citation is AIR 1991, Supreme Court 1853, 3 judges, 1994, 1991, AIR 1991, Supreme Court 1853. Question number 8.
Question number 8. Is it necessary that the inquest should be held at the spot where the dead body is found?
Yes, we notice the expression there in section 174.1. He has to proceed and hold the inquest there, means where the dead body is found, at the exact spot where the dead body is found. Kodali Puranchandra Rao versus Public Prosecutor, AR 1975, Supreme Court 1925. This is no more good law for the reason that the discretion of police officer is taken away. But regarding this, it continues to be valid authority. Question number 9.
Question number 9. Is it correct to say that the FIR loses its authenticity if it is lodged after the inquest is held?
See, usually inquest is held after the registration of the FIR. That is the usual practice, because the FIR, what is FIR? First information report regarding the commission of a cognizable offense. It is only after registering that investigation report, the police officer will go to the place where the dead body is found and hold inquest over the dead body. But there can be situations where the registration of the FIR is after the preparation of the inquest report. So you cannot generalize that once FIR is registered after the inquest is held, the FIR loses its authenticity. You cannot generalize. It all depends on the facts and circumstances of the case. In Shambhu Das versus Bijoy Das, Shambhu Das alias Bijoy Das versus State of Assam, AR 2010, Supreme Court 3300, judgment by Justice H.L. Datu. In this case, the inquest report was prepared at 9:30 p.m. Formal FIR was registered only at 11:30 p.m. 2 hours after the inquest. But court noticed that the GD entry regarding the occurrence had been recorded at 6:30 p.m. before that. So that could have been treated as the FIR. Subsequent FIR is actually hit by section 162 CRPC. And the argument of that the FIR loses its authenticity was repelled. In Balaka Singh versus State of Punjab, 1975, Volume 4 SEC 511, 1975, 4 SEC 511. The FIR contained the names of 9 accused, but the inquest report prepared earlier contained only the names of five persons. No explanation was forthcoming from the side of the prosecution for the missing 4 names in the inquest report. Supreme Court held that FIR could have been anti-timed and therefore it loses its authenticity. Those of you who are relying on, who are appearing for the defense can take advantage of this decision to say that this is a fit case where FIR loses its authenticity. Again, Ramesh Babu Rao versus Ramesh Babu Rao Devaskar versus State of Maharashtra, 2007, Volume 13 SEC 501. The FIR was lodged after the inquest was held. No eyewitness gave the FIR, but the basis for the inquest report was the statement of an eyewitness, version given by an alleged eyewitness. There was also a delay of 4 days in the FIR reaching the magistrate under section 157 of the CRPC. The court held that it was hazardous. It was hazardous to record a conviction on such material. This also can be made use of by those defense lawyers who want to say that FIR cannot be relied on in this case. Question number 10, Sunita.
Question number 10. Do not discrepancy, overwriting, omission, or contradiction in the inquest report render it liable to be eschewed from consideration?
Here again, it all depends on the facts and circumstances of the case. Unless the overwriting, omission, contradiction, etc. have been put to the author of the inquest report and his explanation elicited. See, the author of the inquest report will be in the witness box. At that time, no question will be put to him. Do you see this inquest report? You prepared this inquest report? Yes. How do you explain for this omission? How do you explain for this improvement? How do you explain for this overwriting? How do you explain for this discrepancy? No question asked. Then at the stage of arguments, if you raise a contention that inquest report should not be relied on because it is it contains a lot of overwriting, etc. Court will not be inclined to accept that because the author of the inquest report was in the witness box. You had an opportunity to question him regarding all those irregularities. No question was asked. Therefore, you can't do that. Mohan Singh versus alias Lal Sahib versus State of UP, 2000, AR 2006 Supreme Court, 951, 3 judges. Then again, where the case of the prosecution is strong and substantiated by reliable evidence, lapses including overwriting in the inquest report may not be relevant. If there is other very strong evidence supporting the prosecution case, for example, eyewitnesses who no dent could have been made on their testimony in court, then merely because there is some discrepancy in the inquest report, courts will not be inclined to accept an argument that its authenticity, there is a lot of irregularities in the inquest report. Sakhwinder Singh versus State of Punjab, 2014, Volume 12 SEC 490. 2014, Volume 12 SEC 490. Again, where the discrepancy in the date of lodging the FIR mentioned in the inquest report was not put to the author of the inquest report, no adverse inference can be drawn against the prosecution. We already given the citation. Radha Mohan Singh versus State of UP, AR 2006 Supreme Court, 951, 3 judges. Question 11, Sunita.
Question number 11. Will interpolation in the inquest report render the prosecution case doubtful?
Yes, this is one case where interpolation, that is writing in between the lines, in the inquest report was held to render the prosecution case doubtful. Those of you who want to raise this contention can rely on this ruling. State of Haryana versus Shibu alias Shiv Narayan, 2008, volume 11 SEC 377. 2008, volume 11 SEC 377. Question 12, Sunita.
Question number 12. Is it open for the defense to falsify the prosecution version by relying on a document produced by the prosecution but not exhibited or formally proved by the prosecution?
Yes. Yeah, just because the document has not been marked or at the instance of the prosecution, defense can take advantage of that to disprove the case of the prosecution. It was so held by Ramaya alias Rama versus State of Karnataka. AR 2014 Supreme Court 3388. 2014 Supreme Court 3388. Question number 13.
Question number 13. Is it usual to mention in the inquest report a gist of the FIR and the cause of death as narrated by the witnesses?
Usually, it is usual because inquest report is preceded by the registration of an FIR. Therefore, the gist of the FIR will be there in the inquest report. It is usual. That is not, you can't say that it is foreign to the holding of the inquest. You may refer to AR 2002 Supreme Court 175. AR 2002 Supreme Court 175. But and in one case, substitution of the correct name of the informant in the inquest report was subsequently justified. That is State of UP versus Ram Swaroop, AR 1988 Supreme Court 1028. AR 1988 Supreme Court 1028, 3 judges. Again, omission to mention the crime number in the inquest report, because the inquest report will be preceded by the registration of the FIR. In a case, the inquest report did not contain the crime number. The Supreme Court held that it is not material. If there is other evidence to show that registration of FIR earlier, if there was other evidence to show that there was an FIR registered earlier and the inquest was conducted subsequently, then the absence of mention of the FIR in the inquest report may not be so material. Dr. Krishna Pal versus State of UP, AR 1996 Supreme Court 733. AR 1996 Supreme Court 733. Question 14.
Question number 14. Is it not correct to say that both the inquest report and the postmortem report are substantive evidence?
Inquest report and postmortem report are not substantive evidence, because both these, the persons who, the officer who holds the inquest and the medical officer who conducts postmortem are not witnesses of truth. They have not seen the occurrence. Therefore, they are not, that is not substantive evidence. Of course, not the whole of it, but most of it is not substantive evidence, and it can be used only for corroboration while the witness is in the witness box. You may refer to Madhu alias Maduranatha versus State of Karnataka, AR 2014 Supreme Court 394. AR 2014 Supreme Court 394. Question 15, Sunita.
Question number 15. Can the SHO, who does an official act by preparing the inquest report, etc., be guilty of causing disappearance of evidence of offense punishable under Section 201 IPC?
There the prosecutor was argued, the public prosecutor argued, here is a public officer, public servant conducting an inquest in compliance of his statutory duty. Therefore, you can presume that official acts have been regularly performed. Under 114, the court can presume that all official acts have been regularly performed. Nothing doing. Supreme Court said nothing doing. If in a given case, it has been shown that he has been guilty of laches, he has been guilty of dishonesty, you can't draw the presumption. Kodali Puranchandra Rao versus Public Prosecutor Andhra Pradesh, AR 1975, Supreme Court 1925, 3 judges. In this case, on receiving information about the recovery of dead bodies, the sub-inspector, feigning ignorance and flouting all salutary requirements of section 174 CRPC, prepared false records regarding the identity of the dead bodies, cause of death, etc., and indulged in falsification of data, etc. It was held that you can't draw any presumption of regularity of official act. Supreme Court said. Question 16, Sunita.
Question number 16. In spite of a written application to the police to investigate into the alleged murder of his sister married to one of the accused persons, the police did not register it as an FIR. From the very beginning, the police were attempting to treat the case as one of suicide. If there are circumstances to justify an investigation into the allegation of suspicious murder, is it permissible for the court to direct the police to register the written application as an FIR?
See, in spite of telltale circumstances indicating the commission of murder, the commission of a cognizable offense against the sister of the informant, the police refused to register an FIR. On the contrary, the police were taking a stand that it is a case of suicide. Who are they to decide that? They are not the person to decide that. Therefore, Supreme Court said, we will direct the police to register a crime. That's what the Supreme Court did in Joint Women's Program versus State of Rajasthan. AIR 1987, Supreme Court 2060. AIR 1987, Supreme Court 2060. Yes. Question 17.
Question number 17. Are the statements of witnesses given during the inquiry by the police under Section 174 CRPC hit by Section 162 CRPC?
What is it that a police officer is doing when he is holding an inquest? A police officer holding an inquest is doing something which is part of his investigation under Chapter 12 of CRPC. Therefore, it is hit by Section 162 because 162 says no statement made to a police officer during the course of investigation shall be used, and any part of that statement shall not be used except in the manner provided under the proviso to Section 162(1). Therefore, every statement given to the police officer holding an inquest, every statement given by a witness to a police officer holding an inquest will be hit by Section 162, and the only use of that statement will be to discredit, to elicit a contradiction and discredit the witness. That's all. Citations are Rasik Ram versus J.S. Chauhan, AR 1975, Supreme Court 667, AR 1975, Supreme Court 667, Narpal Singh versus State of Haryana, AR 1977, Supreme Court 1066. Yes. Question number 18.
Question number 18. What is the probative value of the statement of a witness given to the judicial magistrate during an inquiry under Section 176, Clause 1A CRPC?
We have seen that under the newly inserted section subsection 1A to Section 176, if a person is missing from custody, or if a person dies in custody, or if a woman is raped in custody, then the inquiry should be conducted not by executive magistrate but by a judicial magistrate. During the course of inquiry, the judicial magistrate takes statements of witnesses. What is the use of those statements is the question. Those statements are not hit by Section 162 because statements are taken by a judicial magistrate, not a police officer. Therefore, they are not subjected to the interdict under Section 162 CRPC. But therefore, those statements can be treated as any other previous statement and can be subjected to corroboration under Section 157 of the Evidence Act or contradiction under Section 145 of the Evidence Act. Yes. Question 19.
Question number 19. Are not postmortem report and inquest report public documents, and is not the accused entitled to inspect or receive their copies during the stage of investigation?
This is a very, very touchy subject. In fact, the Delhi High Court has taken the view that they are not public documents, and accused is not entitled to inspect or receive copies of those reports during the stage of investigation. State versus Gyan Singh, 1981, Criminal Law Journal 538, Delhi High Court. 1981, Criminal Law Journal 538. Likewise, the Bombay High Court also, accused will be entitled to copies in the interest of fair trial, but only at the appropriate time. Appropriate time is during compliance of Section 207 CRPC. Palani Swami Vayapuri versus State AR 1968 Bombay. 1968 Criminal Law Journal. 1968 Criminal Law Journal 453 Bombay. 1968 Criminal Law Journal 453. In fact, in the recent judgment of the Supreme Court rendered on 8/10/2020, 8/10/2020, in Miss A versus State of UP, Criminal Appeal 659 of 2020, Supreme Court has held that merely because the charge sheet has been filed before court, the accused is not entitled to a copy of the 164 statement of the victim or witness, and that he is entitled to that statement only during compliance of Section 207 CRPC. Filing of the charge, in fact, the High Court in that case had ordered the police to order the court below to give him a copy of the copy of the 164 statement. But charge sheet had already been filed, but court had not taken cognizance of the offence. Therefore, the Supreme Court said, I think the three-judge bench of the Supreme Court, wherein they held that this will be the law hereafter, that he will be entitled to the state copy of the 164 statement only after taking cognizance, issues so process to the accused, and accused appears in response to the process, and at the stage of compliance of Section 207 CRPC, wherein the copies of the prosecution records are being furnished to him, being supplied to him. Because under 173(5), Section 173(5), prosecution has to produce all documents relied on by it before the court, and a copy is to be provided along with the original, and those copies will be given to the accused. That is the stage of under Section 207. It is only at that stage that the accused will be entitled to a copy of the 164 statement, not before. Yes. Question 20.
Question number 20. Are the police bound to register an FIR as if in a cognizable offence in the case of a missing person?
In the case of missing persons, see, normally the state, every state governments will have their own police act, state police act. Likewise, Kerala Police Act also, that is Kerala Police Act 2011, Section 57 directs the state police to attempt to locate. In fact, the state they are not there's a measure for registering an FIR on man missing, and the Section 57 of the Kerala Police Act 2011 directs the state police to attempt to locate the missing persons after registering any information received in the same manner as in the case of cognizable offence, and take immediate action to locate the missing person. Same manner as if in the case of cognizable offence means the same manner as if an FIR is registered under Section 154 in the FIR book, and then after registering the crime or FIR, technically there is no cognizable offence disclosed at that stage. All that is made out is a particular man or woman is missing. That's all. Yet to find out whether any offence has been committed against him. But in view of the provision in the Police Act, State Police Act, they are bound to register the case as if in a cognizable offence and try to locate the missing person at the earliest opportunity. This has been power of the police, or this obligation of the statutory obligation of the police, has been highlighted by a division bench of the Kerala High Court in Anil Kumar versus Sati Kumari, 2012, 1 KHC 531 division bench corresponding to 2012 1 KLT 641. The said decision has also directed that in case of missing persons has been finally traced out, the police shall not release him or her. In case the missing person is finally located, police have no authority, no business to release him or her. The police should produce the person before the magistrate having jurisdiction, and the magistrate will decide whether the missing person should be allowed to go or not. The division bench also clarified that it is not for the police to decide whether the missing person was under illegal detention or not, and that the judiciary alone can decide that question. All these things have been decided by the division bench of the Kerala High Court. Question number 21. Sunita.
Question number 21. Are not the statements in the inquest report as to what the SHO saw and found on the dead body hit by section 162 CRPC?
We saw that an inquest report statements given to the police officer holding an inquest are hit by section 162. In the inquest report, there are so many matters which is gathered by the police officer from the dead body, the wounds, the location of the wounds, etc. Those things are perceived by his senses. The officer is perceiving from his senses. He is not gathering it from any other person. He is actually seeing them. The deep penetrating wound on the left side of the chest found on the body. He is perceiving it with his own senses. Therefore, that part of the inquest report will not be hit by section 162. It is primary evidence. Therefore, it is not hit by 162. But supposing a witness says, I saw this person being murdered by somebody. Investigating police officer has no direct knowledge about the murder. His source of information is from a witness. That part of the inquest report which record the statement of the witness will be hit by section 162. So part of the inquest report can be hit by 162 and part of the inquest report will not be hit by 162 because it is directly perceived by the officer with his own senses. AR 1998 Supreme Court 1376. 1998 Supreme Court 1376. George versus State of Kerala. Question 22.
Question number 22. Are the statements of witnesses recorded by a police officer at the time of inquest during an inquiry under section 174 CRPC subject to the embargo under section 162 CRPC?
There is a confusion because if a police officer conducting an investigation into a cognizable offense registered under section 154 CRPC, FIR registered under 154 CRPC, certainly it is investigation and therefore any statement made to him by witnesses, by any person acquainted with the facts and circumstances of the case will be hit by section 162 CRPC. But here is a case where there is a confusion whether it is investigation or inquiry. Inquiry into the apparent cause of death. There is no crime registered. There is no investigation into a crime. Therefore, there is a confusion whether any statement made to police officer at the time of inquest is hit by section 162 CRPC. It is hit by section 162 CRPC. In fact, section 175 CRPC makes it very clear that it is investigation and it is under chapter 12. If it is an investigation under chapter 12, then any statement made to that officer will be hit by section 162 CRPC. Citation is AR 1974 Supreme Court 1193. AR 1974 Supreme Court 1193. Again, 1996 Volume 6 SCC 457. 1996 Volume 6 SCC 457. With that, I think we have concluded the questions also. It is my policy, or rather my methodology, that any law is better understood when the law is actually applied to concrete fact situations. So these are the concrete fact situations on which we have applied the law, as we have seen. Therefore, that will make you more learned, and you are free to ask questions. Every question will be answered to the best of my knowledge, in ability and capacity. Welcome. host can unmute the querist. Mr. Vinod? Is Mr. Vinod there? Hello? Is Mr. Vinod there?
Yes,
you
sir.
can unmute. They can unmute the querist and any questions can be asked. The querist can be unmuted.
Yes, sir. I think we are actually not having the attendees thing. I will just read out the questions. So, first question: how much maximum time can a police officer take for enquiry under 174 CRPC before filing FIR under 154?
See, 174 doesn't contemplate the filing of an FIR under 154. It is only an inquiry into the apparent cause of death. Supposing during that inquiry he has reason to suspect the commission of a cognizable offense, then the procedure is he has already intimated the executive magistrate under section 174 that there is an unnatural death. I am proceeding to hold inquest over the dead body. Dead body is lying there. So he has already intimated the executive magistrate. Once after the inquiry, and no time limit is actually fixed, but he has to act fast because the body will have to be sent for postmortem examination, autopsy, necropsy, and then if he wants to. So therefore, if after the inquiry he has reason to suspect the commission of a cognizable offense, the procedure is he will send a report to the executive magistrate. My inquiry revealed that there's a cognizable offense committed in respect of this against this person who has been murdered. Therefore, this was originally registered as under section 174 CRPC. Now I am going to incorporate section 302 IPC, and the FIR and the records, maybe my report, etc., may kindly be transferred to the judicial magistrate having jurisdiction. Because once an FIR under section 154 regarding the commission of a cognizable offense is registered, under section 157, the police officer has got a mandatory duty to send a report to the judicial magistrate having nearest magistrate or judicial magistrate having jurisdiction. Therefore, please transfer these records, including FIR registered under 174, to the judicial magistrate having jurisdiction. Because once an offense is disclosed, then it is for the judicial magistrate to deal with the offense. And if ultimately, after holding an inquiry, etc., he will have to commit the case to the court of session for trial, being an offense exclusively triable by a court of session. Yes. No time limit is prescribed, but he has to act fast. Because even for investigation, the time limit prescribed under section 57 CRPC is only 24 hours. It is that time limit which has been extended to 60 days and 90 days under 167 CRPC. So that if the investigating officer does not conclude the investigation within 60 days or 90 days, depending on the punishment which can be imposed to the accused.
Yes, sir.
The penalty he suffers is the accused will be released on bail, default bail. Accused will be released on default bail. This is the penalty he suffers. Therefore, even for completion of investigation, the period fixed under section 57 is 24 hours. Every investigating officer should bear this in mind. Yes.
So the second question,
yes.
If a person dies of burn injuries in the autopsy necessary to be conducted, is
yes.
it necessary?
Autopsy?
Is it necessarily that the autopsy should be conducted?
Yes.
Okay.
Why doubt? It is an unnatural death. It may evoke even nowadays, even when a person dies in the hospital after surgery or something like that, police usually insist on autopsy, the inquest because there could be some complaint thereafter that there was some professional negligence on the part of the doctors. For the safety of all concerned, they recommend that a autopsy and postmortem autopsy should be conducted, inquest and autopsy. Therefore, That will always steer clear of any lingering doubt in somebody who might not come forward then, who may come forward later with an allegation. Therefore, it is always safer because near relatives will file. Why should he, after all, he is dead and gone? Why should his body be cut to pieces, cut and etc.? Let us not have that such sentiments.
Sure, sir. So the third question,
yes.
What if there are discrepancies between the findings of the inquest report and an autopsy report? Which report shall be given the preference?
Definitely autopsy. Inquest is an apparent cause of death, whereas autopsy is by a medical expert. He has his views will have to prevail.
Yes, sir. So next question. In section 174(2), it is mentioned that the other persons who concur with the police officer shall also sign on the inquest report.
Yes.
Are these other persons witness to the inquest?
Yes. Witness to the, who are called as Panchayat Das. They are called to witness the inquest, and they will subscribe their signature. So he will read their statements and they will be asked to sign. Of course, it is being part of the investigation. Those statements will be hit by section 162 during trial. Not at that stage, but during the trial of the case. Yes.
Next question, sir. What are the steps to be followed if there is a death in police custody?
176 1A. Section 1, subsection 1A of section 176. The judicial inquiry, an inquiry by a judicial magistrate, not executive magistrate, because law does not have trust in the executive magistrate. That is why when death has happened in the police custody or any other custody ordered by the magistrate, the inquiry should be conducted by a judicial magistrate. It has more sanctity, more credibility. Yes.
Fine, sir. Next question. Who has got the power of holding inquest in an exhumation case? The magistrate or the investigating officer?
They are the executive magistrate.
Exhumation case.
Investigating officer cannot take the body for exhumation. He has no authority. The executive magistrate alone can order exhumation. The body can be disinterred only on the directions of the magistrate, not by the police officer. He has no authority.
Fine, sir. I'm just checking for. Next question, sir. Can there be a simultaneous inquest by IO as well as executive magistrate, or by the executive magistrate only?
I don't think there's any bar. I don't think any bar. But simultaneous means the inquest held by the police will ordinarily inquest by the police should be the first step. Then only the executive magistrate should come. Especially in cases covered by 174(3) clauses 1 and 2. The death of a married woman within 7 years of her marriage. Those two clauses where the executive magistrate has to necessarily conduct an inquiry. Whether the police has conducted an inquiry or not. Therefore, police inquiry should precede ordinarily the inquiry by the executive magistrate. But supposing it is simultaneously done, nothing wrong. Law does not prohibit. But ordinarily, police inquiry is the first inquiry. Then only the magisterial inquiry will commence. Ordinarily. Yes. Any more questions?
So, question. I'll just take one last question before we end the session.
Okay.
What does peculiar statement to be hit by S162 of CRPC mean? I'm hit by section 162 of CRPC.
That is it is not technically a topic for today, but I have taken a class on contradictions, omissions, and the impact of section 162 CRPC. See, any statement made by a person, whether he be a witness or accused, person acquainted with the facts and circumstances of the case, any statement made by a person to a police officer shall not be used for any purpose during the trial of the case except for eliciting a contradiction. Now, under section 162, if he is a prosecution witness, a contradiction can be elicited from him, and that too for the limited purpose of discrediting him. See, when that is how the mechanics is this way. Supposing a person has given a statement to the police officer during investigation. Then during trial, while he is examined as a witness in the witness box, he gives a totally contradictory statement to what he is told before the police. Then the procedure is his attention should be invited to the contradictory statement occurring in the police statement. And he should be asked, so you seem to have made such a statement to the police. Now you have made a totally contradictory statement before the court. Now what have you got to say? His explanation has to be elicited. If he admits that he did make such a statement to the police, then no further proof is necessary. It amounts to a contradiction. Contradiction means the statement given to the police and the statement given in court are so irreconcilable, are so inconsistent that both cannot coexist. Both statements cannot coexist. If you accept one, the other will be false. If you accept the other, this will be false. Therefore, both cannot coexist. This is a contradiction. When such a contradiction is there, that contradiction has to be proved. If the witness admits that contradiction, that is proof. If he denies that contradiction, no, I did not tell so before the police, then the police officer who questioned him and recorded his statement will have to be examined. And he will have to say, no, what this witness says is not correct. I questioned him. At that time, he made such a statement. So then that contradiction is proved. Even though it is, you call it proved, you cannot take it as substantive evidence for or against the prosecution. It can be used only for discrediting the witness. Here is a witness who made a statement before the police, who made a diametrically opposite statement in court. Therefore, he is a person who cannot be believed. But provided the contradiction is on a material aspect of the question of the trial, then court can say that he is a person who cannot be believed. He made a totally contradictory statement before the police and before this court. Which is true, nobody knows. God alone knows. Therefore, I prefer to disbelieve this witness. That's all. It cannot be used as a substantive evidence either for or against the prosecution. This is contradiction.
Thank you, sir. Thank you very much, sir. So with this question, we have come to the close of the session, and as always, it has been a very engaging session, sir. And I think a lot of interaction has come from the audience itself, and we'd hope to host you again soon. Thank you very much for your time, sir, and thanks, audience, for being a patient listeners to the session. Thank you very much.
Thank you, Sunita. Sunita also.
Thanks, Sunita.